Have you spent time and money creating a trust, only to assume the hard part is over? What if I told you one of the biggest estate planning mistakes happens after the trust is signed? In fact, many families discover too late that the trust they carefully created doesn't actually control their assets. Why? Because the trust was never properly funded. And when that happens, assets that were supposed to avoid probate may end up going through probate anyway. I'm Anna Burr with Burr Law. Today, we're talking about one of the most important and most misunderstood parts of estate planning, funding your trust. It is not the most exciting topic, but it may be one of the most important things you do to make sure your estate plan actually works the way you intended. Let's start with the basics. Many people believe that once they sign their trust documents, everything is automatically protected. That is a very common misunderstanding. Creating the trust is only the first step. Funding the trust is what brings it to life. So what does funding a trust actually mean? Simply put, it means transferring ownership of your assets into the name of the trust. Instead of owning assets as an individual, the trust becomes the legal owner. Think of your trust as a box. Creating the trust builds the box. Funding the trust is what puts your assets inside the box. An empty box doesn't accomplish very much, and an unfunded trust may not accomplish what you intended either. Let's talk about why this matters. One of the primary reasons people create a revocable living trust is to avoid probate. Probate can be time-consuming, expensive, and extraordinarily stressful. A properly funded trust allows assets to pass according to your instructions without requiring the court process that probate often involves. But here's the catch. If assets remain in your individual name when you pass, those assets may still have to go through probate, even if you have a trust sitting in your filing cabinet. That's why funding is so important. It's what makes the trust effective. So which assets should typically be transferred into a trust? Every situation is different, but common examples include your home and other real estate, bank accounts, investments, business interests, and certain types of personal property. These are often some of the most valuable assets people own, and they are frequently the assets that people want their trust to control. Now, some assets require a different approach. Retirement accounts, such as our IRAs and 401ks, are usually not retitled into a trust during your lifetime. Instead, they're coordinated through beneficiary designations. The same can be true for certain life insurance policies and annuities. This is why estate planning isn't just about documents. It's about planning, making sure all the pieces work together the way you want them to. Now let's discuss how assets are actually transferred. The process depends on the type of asset involved. For real estate, a new deed is typically prepared that transfers ownership from you as an individual to you as trustee of your trust. For bank and investment accounts, your financial institution may require paperwork to retitle the trust into the account's name. For personal property, an assignment document is often used to transfer ownership into the trust. Each asset category has its own process. That's one reason many people choose to work with an attorney to ensure everything is completed correctly. Another area where mistakes commonly happen is beneficiary designations. Many people forget that certain assets pass according to the beneficiary form on file, not according to the terms of the trust. This could be life insurance policies, retirement accounts, annuities. These assets may bypass your trust entirely unless beneficiary designations are reviewed and coordinated properly. We've seen situations where someone carefully created an estate plan but never updated an old beneficiary form. As a result, assets ended up going somewhere completely different than where they were intended. That's a mistake that can often be prevented with proper planning and periodic reviews. And that brings us to another important point. Funding your trust isn't necessarily a one-and-done event. Life changes. You may buy a new home, create a new investment account, start a business, receive an inheritance. Each time your financial picture changes, your trust should be reviewed to make sure new assets are properly incorporated into your plan. Otherwise, those assets could be accidentally left outside the trust. Think of estate planning as an ongoing maintenance process rather than a one-time transaction. The goal is keeping your plan aligned with your life, including as your life changes and develops. At the end of the day, creating a trust is a powerful step toward protecting your family and preserving your legacy. But signing the documents is only part of the process. Funding the trust is what allows it to do its job. It's what helps avoid probate. It helps streamline the administration of your estate. It helps ensure your wishes are carried out the way you intended. The good news is that you don't have to figure this all out on your own. At Burr Law, we help families not only create trusts, but also properly fund and maintain them so their estates work when they're needed most. If you're not sure whether your trust has been fully funded or if you've recently acquired new assets, now is a great time to review your plan. Contact our office to schedule a consultation and review. We'll make sure your trust is doing exactly what it was designed to do. Thank you so much for being here today. If you found this helpful, please like, subscribe, or share it with someone you care about. We'll see you next time.